Before we begin, a quick and important disclaimer. This content is for educational and entertainment purposes only and does not constitute professional legal advice or an attorney-client relationship. Legal standards, historical interpretations, and outcomes vary significantly based on jurisdiction, specific facts, and evolving case law. You should not rely on this information to make legal decisions. Always consult with a qualified legal professional in your state to discuss your individual circumstances and conduct your own due diligence regarding any legal matter. In 1948, a private investigator and a lawyer in New York City stood outside a hotel room door, waiting for the perfect moment to burst inside. They were not looking for a criminal or a spy. They were looking for a woman in a negligee who had been paid $50 to sit on a bed with a married man. This was not a real affair. It was a staged production, a piece of legal theater meticulously choreographed by a divorce lawyer. In this era, if you wanted to end a marriage, you had to prove a crime or a sin. Without a provable fault like adultery, the state would keep you shackled to your spouse forever. This led to a surreal underground industry where lawyers became directors of fraudulent scandals, hiring actors and photographers to manufacture evidence for a judge who often knew exactly what was happening, but played along anyway. This is the dark, fascinating, and often bizarre history of the American divorce lawyer, a profession that evolved from a rare, high society specialty into a multi-billion-dollar industry that shapes the most intimate aspects of American life. Understanding this history is not just about looking at the past. It solves a massive problem for you today. It explains why the modern legal system feels so adversarial, why certain laws regarding assets and alimony seem stuck in the 19th century, and how you can navigate a system that was originally designed to prevent people from ever leaving each other. By the end of this deep dive, you will understand the historical trends that created the modern courtroom, the case studies that shifted American culture, and the potential outcomes of a system that is still evolving from its rigid, moralistic roots. To understand where the divorce lawyer stands today, we have to go back to the mid-19th century. In the early days of the United States, divorce was not a judicial matter handled by lawyers in a courtroom. It was a legislative matter. If you wanted a divorce in states like Virginia or South Carolina, you actually had to petition the state legislature. You needed a literal act of assembly. This meant that the early divorce lawyer was more of a lobbyist or a political fixer than a litigator. They had to convince politicians that a marriage was so broken that it required the state to intervene and pass a specific law just for one couple. Because this was expensive and required immense social capital, divorce was almost exclusively reserved for the wealthy and the powerful. For the average person, if a marriage failed, they didn't see a lawyer. They simply vanished, committed bigamy in another state, or lived in what was known as a poor man's divorce, which was essentially just abandonment. As the 1800s progressed, the role of the lawyer shifted from the statehouse to the courthouse. This transition created the fault-based system, which would dominate the American legal landscape for over 100 years. Under this system, a lawyer's job was not to negotiate a fair split of assets. Their job was to act as a prosecutor. To get a decree of divorce, one party had to be innocent, and the other had to be guilty of a specific statutory offense. These offenses usually included adultery, extreme cruelty, or willful desertion. This created an incredibly high-stakes environment. If a lawyer couldn't prove the spouse was a monster, the client stayed married. This era gave birth to the first iteration of the aggressive divorce attorney. Lawyers began to work closely with private detectives, and the courtroom became a battlefield of character assassination. Let's look at a historical trend that emerged during the late 19th century in Indiana and Illinois. These states became the first divorce mills of the U.S. Lawyers in these jurisdictions realized that if they could interpret cruelty broadly, they could attract clients from all over the country. An Indiana lawyer in 1870 might argue that a husband's refusal to take his wife to the theater constituted mental cruelty, sufficient for a divorce. This was the first time we saw the commercialization of divorce law. Lawyers began placing advertisements in Eastern newspapers, promising quick results and low residency requirements. This created a massive tension between states. The legal profession was split between the moralists who wanted to keep divorce difficult and the pragmatists who saw a massive market demand for marital freedom. The early 20th century saw the rise of the migratory divorce and the legendary Reno lawyer. By the 1920s, Nevada had shortened its residency requirement to just 6 weeks. Lawyers in Reno built an entire infrastructure to support this. They weren't just practicing law, they were managing logistics. A Reno divorce lawyer in the 1930s would meet a client at the train station, set them up in a divorce ranch, where they would live for 6 weeks to establish residency, and then walk them through a 5-minute hearing. This era is a fascinating case study in how lawyers can drive legislative change to create a local industry. These lawyers were some of the first to specialize exclusively in matrimonial law, moving away from the general practitioner model. They were often viewed with suspicion by the American Bar Association, labeled as shysters or ambulance chasers of the domestic world, but they were providing a service that millions of Americans were desperate for. However, the most significant evolution in the lawyer's role came from the need to circumvent the collusion trap. In many states, if both parties wanted a divorce, the judge would actually deny it. The law stated that divorce could only be granted to an unwilling victim of a guilty spouse. If a lawyer was caught colluding or agreeing with the other side to end the marriage, the case was dismissed. This led to the era of staged adultery mentioned earlier. Lawyers had to become masters of a wink and nod system. They would hire a woman, often called a correspondent, to be found in a hotel room with the husband. The lawyer would then discover them with a photographer. In the courtroom, the lawyer would present the photos, the husband would offer no defense, and the judge would grant the divorce. It was a legal fiction that everyone participated in. It showed that the role of the lawyer at that time was less about justice and more about navigating a hypocritical moral code using elaborate loopholes. Data from the mid-20th century shows that while the population was growing, the number of lawyers specializing in divorce was exploding even faster. This was because the complexity of the fault system required more billable hours and more investigative work. Before the 1970s, a divorce lawyer spent 80% of their time proving why the marriage should end and only 20% on how the assets should be divided. This is the complete opposite of the modern role. In these historical case studies, we see the lawyer as a gatekeeper of morality. They were the ones who decided which stories were bad enough to merit a legal exit. Then came the 1969 no-fault revolution, beginning in California. This shifted the lawyer's role almost overnight from a detective and prosecutor to a financial strategist and negotiator. When Governor Ronald Reagan signed the first no-fault divorce bill, the historical trend shifted from, "Why are you leaving?" to "What are you taking?" This transition is where the modern divorce lawyer was truly born. The focus moved to the equitable distribution of assets and the best interests of the child. In this masterclass, we are going to look at how these historical stages created the specific tactics used in courtrooms today. We will examine how the fault era's emphasis on character assassination evolved into modern parenting evaluations. We will analyze how the Reno divorce mills paved the way for modern jurisdictional battles and forum shopping. By understanding the DNA of this profession, you will see that the divorce lawyer has always been a reflection of American society's struggle between the sanctity of the institution and the individual's right to happiness. This historical context is the key to understanding potential outcomes in any modern domestic case, as the ghosts of these old laws still haunt the statutes of many states today. To understand how deep the roots of the modern divorce lawyer go, we must look at the specific mechanics of the fault-based system that governed the United States for nearly 2 centuries. Imagine if you are a man named Mark living in the year 2026. If Mark and his wife Emily decide they have simply grown apart, they can file for a no-fault divorce in any state and be done with it. But if Mark were living in 1926, his lawyer would have to explain a terrifying reality. The law did not care about his happiness. The law only cared about a crime. In this era, the divorce lawyer was not a mediator. They were an inquisitor. They had to prove that one spouse had committed a fundamental breach of the marital contract, usually defined as adultery, desertion, or extreme physical cruelty. This created a historical trend where lawyers were forced to become masters of the pious fraud. Because the legal standard for divorce was so high, lawyers had to coach their clients on how to present a narrative that fit the narrow statutes. If Mark wanted to leave Emily because she was emotionally distant or they had different life goals, his lawyer would have to tell him that those were not legal grounds. Instead, the lawyer might suggest looking for evidence of extreme cruelty. In the early 20th century, this definition was expanded by clever attorneys to include mental cruelty, but even that was a high bar. A lawyer might have to document every single argument, every instance of silent treatment, and every perceived slight to build a case that the marriage was literally destroying the client's health. Historical trends show that lawyers would often bring in medical doctors as expert witnesses to testify that a husband's verbal abuse was causing a wife's nervous collapse, providing the legal hook necessary to grant a decree. The case studies of this era reveal a level of surveillance that would shock a modern audience. Before the advent of digital footprints and GPS tracking that a 2026 lawyer might use, the divorce lawyer of the 1930s and 40s relied on keyhole peepers. These were private investigators hired by the lawyer to follow the spouse, hide in closets, or peer through windows to catch a glimpse of an illicit encounter. The lawyer's role was to take this raw, often sordid data and transform it into a legal argument for criminal conversation or alienation of affections. These were legal torts where a husband could actually sue his wife's lover for damages. The divorce lawyer in this scenario acted as a bounty hunter, seeking a financial judgment against the interloper who had supposedly stolen the spouse's love. This wasn't just about ending a marriage, it was about litigating the theft of property, as wives were historically viewed under the doctrine of coverture. Step by step, the lawyer had to navigate the innocent spouse doctrine. This was a massive hurdle. If Mark's lawyer proved that Emily committed adultery, but Emily's lawyer proved that Mark also committed adultery, the judge would apply the rule of recrimination. This meant that because both parties were guilty, neither was entitled to a divorce. They were legally forced to stay married as a punishment for their mutual sins. Imagine the level of animosity this created. Lawyers had to advise their clients to be perfectly behaved, or at least perfectly stealthy, throughout the entire litigation process. One slip-up, one retaliatory date, and the entire case would collapse. This historical reality explains why old-school divorce lawyers gained a reputation for being ruthless and manipulative. The system literally demanded it. Data from the New York court system in the 1940s shows that adultery was the only ground for divorce in that state for over a century. This led to a massive rise in migratory divorce case studies. A specialized class of lawyers emerged who did nothing but facilitate the Reno cure. If a client in New York or South Carolina couldn't prove fault, their lawyer would coordinate with a Nevada attorney. The step-by-step process was rigorous. The client would travel to a Reno divorce ranch, stay for exactly 6 weeks to establish residency, and then appear in a Nevada court where the lawyer would present a boilerplate case of mental cruelty. The spouse back home would be served with papers, and as long as they didn't contest it, the Nevada judge would grant the decree. This was a luxury service. Only those who could afford the 6-week stay and the double legal fees of 2 different attorneys could access this loophole. This created a 2-tiered system of justice. The wealthy had lawyers who could navigate the Reno loophole, while the poor were often stuck in legal limbo. If you couldn't afford the Reno lawyer, you might engage in what historians call self-help divorce. This often involved poor man's desertion, where a spouse simply walked away and started a new life under a different name. The role of the lawyer here was non-existent, leading to decades of legal chaos regarding bigamy and inheritance rights when these walk-away spouses eventually died. In the 1950s, the role of the divorce lawyer began to shift toward a more therapeutic model, though it was still hampered by the law. Lawyers began to see the benefit of psychological insights, but the statutes remained rigid. Imagine a lawyer named Robert in 1955. He knows his client is miserable, but he still has to play the fault game. He has to tell his client that if she wants any alimony, historically known as the wages of the wife's virtue, she must remain the innocent party. If a wife was found at fault, even for something as minor as nagging under the definition of cruelty, she could be stripped of all financial support and lose custody of her children. The lawyer was the high-stakes protector of a woman's entire future survival. By the time we reached the mid-1960s, the legal profession was at a breaking point. The staged adultery scandals had become so widespread that the integrity of the judicial system was being questioned. Judges knew the witnesses were lying. Lawyers knew the evidence was faked, and the public knew the system was a charade. This historical trend of institutionalized perjury is what eventually forced the hand of the legislatures. Lawyers themselves began to lobby for change, arguing that their roles as officers of the court were being compromised by the requirement to prove fault. They wanted to move away from being scandalmongers and toward being problem solvers. However, this transition was not easy. The legal community feared that if divorce became too easy, their fees would vanish. They had built an entire economic model on the high-conflict, fault-based trial. This leads us to a pivotal moment in American history, the birth of the no-fault era. This didn't just change the laws. It fundamentally re-engineered the business model of the American law firm. But as the why of divorce vanished, a new, even more complex battleground emerged. The lawyer's focus shifted from the bedroom to the bank account, and the tactics used to find a hidden lover were suddenly repurposed to find hidden offshore accounts. As we move into the next phase of this deep dive, we have to ask, what happened when the law stopped caring about who was good and who was bad? Did it actually make divorce cheaper and faster, or did it just create a new, more sophisticated way for lawyers to keep families in court for years? We are about to look at the California earthquake of 1969 and how it set the stage for the high-asset, high-conflict litigation we see in 2026. Because while the sin might be gone, the stakes only got higher. What happens when a lawyer no longer needs a private eye to find a mistress, but instead needs a forensic accountant to find a Bitcoin wallet? The battle for the modern American fortune was about to begin, and the divorce lawyer was the one holding the map to the treasure. The passage of the 1969 Family Law Act in California, signed into law by Governor Ronald Reagan, was not just a legislative update. It was a structural detonation of the legal landscape. For the first time in American history, a spouse could walk into a lawyer's office and end a marriage simply because they no longer wanted to be in it. This created a seismic shift in the professional identity of the divorce lawyer. No longer were they required to be moral detectives or gatherers of illicit evidence. Instead, they had to transform into sophisticated financial architects. This transition marked the beginning of the end for the private investigator as the primary tool of the domestic litigator, and the rise of the forensic accountant as the new indispensable ally. Imagine a couple in 2026. Let's call them Sarah and David. They have been married for 15 years, a period during which David built a successful software company, and Sarah managed a diverse portfolio of real estate and digital assets. In the old fault-based system, a lawyer's first question to Sarah would have been, is David cheating? Does he drink? Does he hit you? In 2026, the lawyer's first question is far more technical. What is the date of marriage? What was the date of separation? And can you provide the last 5 years of tax returns and K-1 statements? The focus has shifted entirely from the bedroom to the balance sheet. Historical trends show that as the emotional requirement for divorce decreased, the financial complexity increased exponentially. Lawyers had to learn how to value things that were once considered intangible, such as professional degrees, business goodwill, and intellectual property. A landmark case study that illustrates this shift is the 1985 New York case of O'Brien v. O'Brien. In this case, a husband had earned a medical license during the marriage while the wife worked to support him. When they divorced, the lawyer for the wife argued that the medical degree itself was marital property subject to equitable distribution. This was a radical departure from traditional law. The court agreed, ruling that the enhanced earning capacity provided by the degree was a marital asset. This forced divorce lawyers to become experts in actuarial math. They had to calculate the potential outcomes of a career path over 30 years, discount that value to present-day dollars, and then negotiate a split. This step-by-step valuation process became the new standard for high-stakes litigation. A lawyer would hire a vocational expert to testify about what a surgeon earns versus a general practitioner, and then a financial expert would apply a capitalization rate to those earnings. This was a far cry from the hotel room stakeouts of the 1940s. In the year 2026, the complexity for someone like David's lawyer involves assets that didn't even exist when no-fault laws were first drafted. We are now seeing the emergence of the digital forensic divorce. Imagine David has been funneling marital income into decentralized finance protocols, or holding significant positions in various cryptocurrencies. A 2026 divorce lawyer must now perform a digital audit. The step-by-step process involves identifying public wallet addresses, tracing transactions through blockchain explorers, and looking for evidence of cold storage devices. Historical trends in the 1990s focused on hidden offshore bank accounts in the Cayman Islands. Today, the battle is over private keys and seed phrases. The lawyer's role is to ensure that Sarah gets her fair share of these high-volatility assets, which requires a deep understanding of how to value a portfolio that might swing 20% in value between the day of filing and the day of the final decree. This era also saw the birth of the equitable distribution model in states that weren't community property states. Historically, many states followed a title-based system where whoever's name was on the deed owned the property. This was devastating for stay-at-home mothers who had no legal claim to the family home or the husband's pension. Lawyers in the 1970s and 80s fought for the concept that marriage is an economic partnership. This changed the lawyer's job from a simple property clerk to a strategist who argues for fairness over title. They started looking at factors like the duration of the marriage, the health of the parties, and the contributions of a non-earning spouse to the career of the earning spouse. The shift to no fault also fundamentally changed the psychology of the courtroom. When you remove the need to prove a wrong, you also remove the judge's ability to punish a spouse with a smaller settlement. In most modern jurisdictions, the fact that David might have been unfaithful is legally irrelevant to how the bank accounts are split. This is often one of the most difficult things for a client in 2026 to accept. A lawyer today spends a significant amount of time acting as a reality check for their client's emotions. They have to explain that the court is now a cold, calculating machine designed to divide assets and liabilities, not a forum for moral vindication. This has led to the rise of mediation and collaborative law, where lawyers act more like negotiators trying to reach a settlement than gladiators in a coliseum. However, as the financial battles became more technical, a new and darker frontier emerged in the role of the divorce lawyer: the weaponization of child custody. In the early 20th century, the tender years doctrine almost always awarded custody to the mother, unless she was proven to be a fallen woman. But as the 1970s progressed, the standard shifted to the best interests of the child. While this sounds more humane, it actually opened the door for much more invasive and prolonged legal battles. Lawyers began to work with a new class of professionals: the guardian ad litem and the court-appointed psychologist. Step by step, a custody battle in 2026 involves a lawyer coordinating home studies, psychological evaluations, and interviews with teachers and pediatricians. The lawyer's goal is to build a narrative of parental fitness. Because there is no longer a guilty party in the marriage, the guilt is now sought in the parenting. Case studies from the last decade show a disturbing trend of parental alienation claims, where lawyers argue that one parent is brainwashing the child against the other. This has turned divorce lawyers into amateur psychologists who must navigate complex family dynamics and high-conflict personalities. Data shows that custody litigation is now the most expensive and time-consuming part of a divorce, often eclipsing the cost of the financial split. In the 1950s, a custody hearing might last an afternoon. In 2026, a high-conflict custody trial can last weeks and cost hundreds of thousands of dollars. The lawyer is no longer just arguing about who gets the house. They are arguing about who gets the Sunday mornings, the holiday dinners, and the right to decide where a child goes to school. This evolution has made the role of the divorce lawyer one of the most emotionally taxing in the entire legal profession. But what happens when the fight for the children and the fight for the money collide in a way that the law was never designed to handle? What happens when one parent uses the threat of a custody battle to force a better financial settlement? This is the shadow of the law negotiation tactic that defines the modern era. And as we move into our next section, we're going to look at the rise of the super lawyer, the high-stakes celebrity attorneys who represent the 1%. These are the individuals who didn't just follow the law. They created the strategies that now dictate how every divorce in America is handled, from the trailer park to the penthouse. We are going into the world of the bombshell filing, the tactical move that can end a case before it even begins. The emergence of the superlawyer in the late 1970s and early 1980s marked a turning point where the practice of family law stopped being a quiet, backroom negotiation and started becoming a public spectacle. Before this era, even the most contentious divorces were handled with a degree of professional discretion. However, as the American economy boomed and the divorce rate climbed toward its historic peak in 1981, a new breed of legal gladiator stepped into the arena. These were individuals who understood that in a high-asset divorce, the courtroom was only one of several battlefields. The other battlefields were the press, the boardroom, and the social circle of the elite. These lawyers didn't just represent their clients. They managed their reputations and weaponized information in ways that changed the potential outcomes of a case before a judge ever put on a robe. One of the most significant case studies in this transformation is the career of Marvin Mitchelson, a man who essentially invented the concept of palimony. In the mid-1970s, Mitchelson took on the case of Michelle Triola Marvin against the legendary actor Lee Marvin. This was a revolutionary moment because the couple was never actually married. Mitchelson argued that because they had lived together and Michelle had given up her career to support Lee, an implied contract existed that entitled her to a share of his earnings. This was the birth of Marvin versus Marvin, a case that expanded the role of the domestic lawyer into the realm of non-marital contracts. It sent a shockwave through the U.S. legal system. Suddenly, lawyers weren't just looking at marriage licenses. They were looking at cohabitation agreements and verbal promises. Mitchelson became a household name, appearing on talk shows and in tabloids, proving that a divorce lawyer could be a celebrity in their own right. This historical trend of the celebrity lawyer shifted the power dynamic. Now, the lawyer's own brand was a form of leverage. If a high-profile spouse saw that the other side had hired a specific super lawyer, the intimidation factor alone often forced a settlement. This leads us to the tactical masterpiece known as the bombshell filing. To understand this in a 2026 context, imagine a high-profile character named Alex, a founder of a massive fintech startup, and his spouse, Jordan. Alex wants to end the marriage but knows that his company's upcoming IPO is vulnerable to bad press. Alex's lawyer doesn't just file a petition for dissolution. They execute a preemptive strike. Step by step, this involves months of quiet preparation before the spouse even knows a divorce is coming. The lawyer hires a team of forensic experts to map out every asset, prepares a massive filing full of aggressive but legally shielded allegations, and then files the case at 4:30 p.m. on a Friday afternoon. Why Friday? Because it controls the narrative. By filing late on a Friday, the lawyer ensures that the news hits the Saturday papers and weekend blogs when the other side's legal team is likely away from their desks. It creates a 48-hour window where the filing's narrative is the only one the public hears. In 2026, this involves a coordinated release of information to specific social media influencers or digital news outlets to ensure the narrative is framed as Alex being the victim of a difficult situation, rather than the instigator. The bombshell filing is designed to overwhelm the opponent, forcing them into a defensive posture where they are so busy reacting to the allegations and the media firestorm that they cannot focus on the financial discovery process. Historical trends show that these aggressive opening moves often lead to quicker settlements because the targeted spouse simply wants the public pressure to stop. The economics of these elite firms also saw a radical shift. In the 1980s and 90s, the retainer became a status symbol. While a standard lawyer might ask for a $5,000 deposit, the super lawyers began demanding six-figure non-refundable retainers just to clear their calendar. This created a tier of legal service that was effectively a gated community. These firms didn't just bill for hours, they billed for availability. They were on call 24 hours a day, managing emergencies that ranged from a spouse being locked out of a penthouse to a leaked video appearing on a gossip site. The lawyer became a fixer. Case studies from this era, such as those involving Raoul Felder in New York or Laura Wasser in Los Angeles, show a shift toward the discreet exit. Ironically, while Michelson rose to fame through public battles, the next generation of super lawyers gained power by promising to keep their clients out of the headlines. They developed the private judging system, where wealthy couples pay for a retired judge to hear their case in a private law office rather than a public courthouse, keeping the details of their fortunes and their failures off the public record. This evolution introduced a new level of psychological warfare into the process. Lawyers began using the silver bullet tactic, a term often used in legal circles to describe an allegation of misconduct so severe that it effectively ends any chance the other parent has of getting custody. Historically, as the tender years doctrine faded and joint custody became the norm, the only way for one parent to win sole custody was to prove the other parent was unfit. This led to a rise in tactical allegations of abuse or substance issues. A 2026 lawyer must navigate this with extreme caution, as the potential outcomes of a false allegation can backfire spectacularly, but the historical trend remains. In high-stakes cases, the lawyer is often tasked with finding the one piece of information that makes the other side's position untenable. Data from the early 2000s indicates that the cost of high-net-worth divorces began to outpace inflation significantly. This was because the team around the lawyer expanded. A top-tier divorce in 2026 isn't just one lawyer and a secretary. It is a lead litigator, 2 junior associates, a forensic accountant, a private security detail, a PR consultant, and sometimes even a divorce coach to manage the client's emotional stability. The lawyer acts as the CEO of this small corporation. They coordinate the flow of information and decide when to push and when to pivot. This management of the team is what separates the average practitioner from the elite. We also have to look at the role of the prenuptial agreement lawyer. Historically, prenups were viewed as unromantic or even a sign of a doomed marriage. However, through the 1990s and into the 2020s, lawyers transformed them into standard business documents. The lawyer's role shifted from breaking the marriage to insulating the assets before the marriage even began. This created a new paradox. The same lawyer who would fight for a massive settlement for a wife in one case would be the one drafting an ironclad agreement to prevent a settlement for a husband in the next. They became the architects of financial safety nets. But as the elite consolidated their power and their methods, the technology of the world was changing underneath them. The super lawyers of the 90s relied on paper trails and private eyes. The 2026 lawyer is dealing with an entirely different animal. What happens when the paper trail is an encrypted message that deletes itself after 10 seconds? What happens when the hidden asset is a piece of virtual real estate in a metaverse that doesn't have a legal jurisdiction? The role of the lawyer is currently undergoing its most radical transformation yet, as they move from the boardroom into the digital frontier. In the next part, we are going to dive into the digital discovery revolution, where a single deleted text message can be worth $10 million, and why your lawyer might be more interested in your smart refrigerator's data than your bank statements. We are entering the era of the cyber divorce, and the stakes have never been more invisible. To understand the evolution of the divorce lawyer in 2026, we have to recognize that the battlefield has moved from the physical world to the digital ether. In the mid-20th century, a lawyer would look for a receipt for a jewelry store or a stray lipstick stain. By the early 2000s, this evolved into searching through printed emails and looking at phone bills to see which numbers were called frequently at 2 a.m. But today, the digital footprint is so vast and so integrated into our lives that the modern divorce lawyer has essentially become a data scientist. They no longer just subpoena bank records, they subpoena the metadata of a life. Imagine a character named Marcus in 2026. Marcus is a high-level executive who has been married to Elena for 12 years. Marcus believes he has been incredibly careful. He uses encrypted messaging apps that promise end-to-end encryption. He hides his extra spending in a secondary digital wallet that isn't linked to his primary bank account. He even uses a VPN to mask his location when he is somewhere he shouldn't be. In his mind, he is invisible. But Elena's lawyer knows that Marcus lives in a world of smart devices that are constantly narrating his story to the cloud. This is where the digital discovery revolution begins. The first step in this modern legal process is the preservation of evidence. A 2026 divorce lawyer will immediately issue a preservation letter to the opposing party. This is a formal legal notice that warns Marcus that any deletion of data, clearing of browser histories, or wiping of devices will be treated as spoliation of evidence. Historically, if Marcus burned a box of letters in 1950, it was hard to prove what was in them. In 2026, if Marcus deletes a thread on a decentralized messaging platform, the absence of that data, combined with the log files from his device's operating system, can lead a judge to issue an adverse inference. This means the court can legally assume the deleted information was damaging to Marcus's case. The lawyer's role has shifted from finding the smoking gun to proving that Marcus tried to hide the gun. Consider the smart home as a silent witness. Historical trends show that as our homes became smarter, they became more talkative in court. Elena's lawyer might look at the data from the smart thermostat in the marital home. If Marcus claims he was alone and asleep at 10 p.m. on a Tuesday, but the thermostat logs show that the temperature in the guest room was adjusted, and the smart refrigerator recorded 3 door openings, and the dispensing of 2 glasses of filtered water, Marcus has a problem. The lawyer uses this data to establish a pattern of behavior that contradicts his testimony. Step by step, the lawyer builds a timeline using the Internet of Things, IoT. They look at the logs from the smart lock to see exactly when people entered and exited, and they cross-reference this with the Wi-Fi router's logs to see which unauthorized device is connected to the home network. Then there is the issue of wearable technology. Case studies from the early 2020s already showed lawyers using Fitbit data to prove physical activity levels in personal injury cases. In a 2026 divorce, a lawyer might use heart rate and GPS data from a smartwatch to challenge a spouse's claim about their whereabouts or their health. If a spouse is claiming they are too depressed or physically ill to work and therefore require high levels of alimony, but their wearable data shows they are running 5 miles a day and maintaining a social heart rate at a local nightclub, the lawyer has a powerful piece of impeachment evidence. This is a deep dive into the biography of the body, and the lawyer is the one who knows how to translate those biometrics into a legal argument. The financial side of this cyber divorce is even more complex. In the historical trend of the 1980s, a lawyer looked for lifestyle evidence by checking the mailbox for luxury catalogs. Today they look at the blockchain. Marcus might think his cryptocurrency is safe, but the role of the divorce lawyer now involves working with specialized blockchain forensic firms. These experts perform what is known as peeling chain analysis. They trace the flow of funds from a known marital account into a crypto exchange, and then follow the tokens through various mixer services or into non-custodial wallets. In 2026, a lawyer can petition the court to compel Marcus to turn over his private keys or face contempt of court, which could lead to jail time. The potential outcomes for Marcus are severe. If he is found to be hiding digital assets, the judge may award a larger share of the visible marital assets to Elena as a penalty. We also have to look at the rise of AI-assisted discovery. In a typical high-asset divorce today, the sheer volume of data is overwhelming. We are talking about hundreds of thousands of emails, text messages, Slack logs, and social media interactions. A 2026 lawyer doesn't read every message. They use large language models and specialized legal AI to perform sentiment analysis and keyword clustering. They can feed 10 years of communications into a system and ask it to find every instance where Marcus discussed a specific offshore property or used a coded nickname for a hidden lover. This technology has made the finding of information faster, but it has made the interpreting of it more critical. The lawyer's value is no longer in the search. It is in the narrative they build from the search results. However, this new power comes with massive ethical and legal risks. A critical part of the lawyer's role is navigating the Stored Communications Act and the Computer Fraud and Abuse Act. Historically, if a wife found her husband's diary on the nightstand, she could read it and give it to her lawyer. In 2026, if Elena guesses Marcus's password and logs into his cloud storage to download his private files, she might be committing a federal crime. The lawyer must be a gatekeeper. They have to tell their clients, do not hack, do not guess passwords, and do not use spyware. If a lawyer knowingly uses illegally obtained digital evidence, they risk disbarment. This creates a paradox where the lawyer knows the evidence exists, but must wait for the formal discovery process to legally obtain it. Data shows that the cost of this digital forensic work now accounts for up to 40% of the total legal spend in a contested divorce. This is why the modern lawyer must also be a cost-benefit analyst. Is it worth spending $20,000 on a forensic image of a hard drive to find evidence of a $5,000 secret account? The lawyer has to guide the client through the potential outcomes of every digital rabbit hole. As we look at this transition from the physical to the digital, we see a legal profession that is more powerful than ever but also more under pressure. The lawyer is no longer just a representative in court. They are a digital guardian. But what happens when the data doesn't just show an affair or a hidden bank account? What happens when the data shows a fundamental shift in how we define family and parenting? As we move into the next part of this masterclass, we are going to look at the most controversial evolution in the history of the divorce lawyer: the rise of artificial intelligence judges and algorithmic alimony. We are moving into a world where the law isn't just assisted by machines. It might be dictated by them. What happens when a computer decides who gets the kids based on 10 years of your own digital history? The era of the algorithm trial is closer than you think. As we enter 2026, the concept of a judge sitting on a high bench, weighing the testimony of two emotional spouses, is increasingly being supplemented, and in some jurisdictions replaced by predictive analytics and automated decision-making systems. This is the era of the algorithm trial. To understand how we got here, we have to look at the historical trends that began in the early 2010s with the introduction of basic child support calculators. For decades, lawyers used simple math based on state guidelines to determine support. But as computing power increased, so did the ambition of the legal system. The divorce lawyer of 2026 is no longer just a storyteller. They are a prompt engineer and a data auditor, navigating a world where the law is increasingly expressed in code. Imagine Marcus and Elena again. In their 2026 divorce, the question of alimony is not a 4-day evidentiary hearing. Instead, the court utilizes what is known as algorithmic alimony. Historically, alimony was one of the most unpredictable elements of a divorce. A judge in one county might award 5 years of support, while a judge in the next county might award 10 for the exact same set of facts. This inconsistency led to massive legal bills as lawyers fought over the subjective definitions of need and ability to pay. To solve this, many states have moved toward standardized software that analyzes hundreds of variables. Step by step, the 2026 process involves feeding the AI a massive dataset. Not just current salaries, but projected career trajectories based on industry-wide data, the current rate of inflation, the volatility of the couple's specific stock portfolios, and even the local cost of living index for their respective zip codes. The role of the lawyer in this scenario has shifted from arguing about fairness to auditing the inputs. If the algorithm suggests that Marcus should pay Elena $10,000 a month, his lawyer's job is to find the bad data that the machine used to reach that conclusion. Perhaps the software used an outdated growth projection for Marcus's fintech startup. or it failed to account for a specific tax liability associated with their offshore holdings. The lawyer must now be capable of cross-examining the algorithm itself. We are seeing a new class of expert witnesses in the courtroom: algorithmic auditors who testify about the bias or technical flaws in the court-mandated software. This is a far cry from the emotional pleas for justice that defined the 1980s and 90s. However, the most controversial shift in this masterclass of legal history is the rise of the parental fitness score. In the years leading up to 2026, family courts across the United States began experimenting with data-driven custody evaluations. Imagine a software package that scrapes 10 years of digital history from both Marcus and Elena. It looks at their location history to see who spent more time at the park versus the office. It analyzes their screen time logs to see which parent was more engaged with the children during evening hours. It even reviews educational app usage to determine which parent was actively involved in the children's schooling. The machine then produces a score, a numerical representation of parental involvement. In a high-stakes 2026 case, the lawyer's strategy revolves around these scores. If Elena's score is lower because she travels for work, her lawyer must argue that the data is context-blind. They have to prove that while Elena was at the airport, she was engaged in high-quality video calls with the children, which the algorithm might have miscategorized as mere screen time. This is the new litigation: the humanization of the data. The lawyer's task is to provide the narrative that the machine lacks, turning raw numbers back into a human story of sacrifice and effort. Historical trends show that whenever the legal system tries to become more efficient through technology, it creates new forms of inequality. Data from early pilot programs in states like Washington and Illinois suggests that these algorithms often favor the parent with the most traditional, easily tracked digital footprint. A parent who works a cash-based job, or who is highly protective of their digital privacy, might end up with a lower fitness score simply because the machine has less data to analyze. This has created a new potential outcome where the divorce lawyer must advise their clients on how to optimize their digital lives for a future divorce. It is a world where a lawyer might tell a client in 2026 to ensure they are using the court-approved co-parenting app for every single communication, because the algorithm gives higher weight to structured data than to unstructured text messages. Another massive evolution is the mandatory mediation bot. To clear the backlog of cases, many jurisdictions now require couples to go through an AI-mediated settlement process before they are even allowed to see a human judge. The software uses game theory to find the zone of possible agreement between Marcus and Elena. It suggests splits of assets that are mathematically optimal, aimed at minimizing the total tax burden and maximizing the long-term wealth of both parties. For the 2026 divorce lawyer, this means their role has moved upstream. They are now strategists who prepare their clients for the bot. They conduct dry runs with their own proprietary AI to see what the court spot is likely to suggest. The lawyer becomes a grandmaster of a legal chess game, where the first 50 moves are played out by computers before a human ever enters the room. We also see the emergence of the social credit impact on divorce. In some modern case studies, lawyers are using social media sentiment analysis to argue for or against a parent's reputation. If a parent is canceled or suffers a massive loss in their digital social standing, a 2026 lawyer may argue that this constitutes a change in circumstances that affects the best interests of the child. The lawyer of the past looked for a mistress in a hotel. The lawyer of today looks for a drop in an influencer's engagement metrics as a sign of instability. But as the machines take over the math and the monitoring, they are exposing a deeper truth about the American legal system. While an algorithm can divide a bank account and a computer can track a location, they cannot handle the human impulse for retribution. In fact, as the legal side of divorce becomes more automated and predictable, the emotional side is becoming more explosive. People who feel they have been processed by a machine often look for other ways to feel heard or to find revenge. This leads us to a dark historical trend that has only accelerated in the era of high technology: the weaponization of the legal process itself. When the law becomes a predictable machine, those who want to cause harm find ways to jam the gears. In the next part of our deep dive, we are going to look at the world of dirty litigation. We will explore the tactics of legal abuse, where the goal isn't to win the case, but to bankrupt the other side through a series of endless, automated filings and procedural hurdles. We are going to look at the rise of the vexatious litigator, and how the modern lawyer has to act as a shield against a system that can be used as a weapon of financial and emotional attrition. What happens when the law is no longer a path to a solution, but a tool for a slow-motion war? We are going into the shadows of the courtroom, where the most dangerous moves are the ones that never make it to the final decree. In the shadows of the courtroom, where the objective is no longer a fair resolution but total annihilation, the divorce lawyer assumes their most controversial role, the architect of lawfare. In 2026, the legal system has become so efficient that those who wish to cause harm have had to find new ways to jam the gears of justice. This is not about the law. It is about attrition. It is a historical trend that traces its roots back to the 1980s, an era defined by high-conflict celebrity divorces that birthed the scorched earth strategy. To understand the modern divorce lawyer, you must understand how the process itself can be transformed into a weapon of financial and psychological terror. Imagine a scenario in 2026 involving a couple named Sarah and Thomas. Thomas is a high-earning corporate executive who is deeply resentful of the divorce filing. He does not just want to keep his assets. He wants to ensure that Sarah leaves the marriage with nothing but her legal bills. He hires a lawyer known for aggressive motion practice. This lawyer does not start by looking for a settlement. Instead, they initiate a process of financial attrition. The strategy is simple. Make the divorce so expensive and so exhausting that the other side surrenders just to make the pain stop. The first step in this process is the paper blizzard. Historically, in the 1990s, this involved sending boxes of unorganized documents to the opposing counsel, forcing them to spend hundreds of billable hours sorting through junk to find one relevant bank statement. In 2026, this has evolved into digital flooding. Thomas's lawyer uses AI-driven tools to generate thousands of discovery requests. They ask for every text message Sarah has sent in the last 15 years, every social media interaction, every receipt from every grocery store, and metadata for every photo on her cloud storage. While the law requires requests to be reasonable, the burden of proving that these requests are unreasonable falls on Sarah. Her lawyer must file a protective order for every single request, a process that can cost thousands of dollars in fees before a single piece of evidence is even reviewed. Historical trends show that this type of legal abuse is often a slow-motion war. Case studies from the early 2000s highlight how wealthy litigants would file motion after motion, requests to change the venue, motions to recuse the judge, and motions to compel discovery that had already been provided. In 2026, this is called motion churning. For every week Sarah tries to move the case forward, Thomas's lawyer files 3 new motions that require a response and a hearing. Because court calendars in major U.S. cities are still backed up, each motion can delay the final trial by months. For Thomas, who has a high income, these legal fees are a business expense. For Sarah, who may have limited access to marital funds during the pendency of the case, these fees are a death sentence to her financial stability. The role of the lawyer here is ethically ambiguous. Under the American Bar Association's model rules, a lawyer has a duty to provide zealous advocacy for their client. However, they also have a duty not to bring frivolous claims. The problem is that in the hands of a skilled litigator, almost any motion can be framed as having a legitimate legal basis. A motion to reconsider a custody ruling might be filed not because the lawyer expects to win, but because the filing itself triggers a new round of psychological evaluations for the children, further stressing the other parent. This is the shadow of the law where the process is the punishment. Let us dive deeper into the deposition marathon, a tactic that has remained remarkably consistent since the 1970s, but has become more refined. Imagine Sarah being forced to sit in a conference room for 14 hours over 2 days. Thomas's lawyer asks her the same questions in 20 different ways, probing for minor inconsistencies that can be used to destroy her credibility. They ask about her parenting choices in 2018, her spending habits in 2021, and her private conversations with friends. The goal is not just to get information, it is to induce a breakdown. In 2026, these depositions are often recorded in high-definition video, specifically so that clips of the spouse looking tired, angry, or confused can be played in court to create a narrative of instability. The divorce lawyer acts as a director, setting the stage for a performance that will be used to influence a judge or a custody evaluator. A significant historical shift occurred with the rise of the vexatious litigator status. Courts eventually realized that some individuals were using the legal system to harass their former partners. If a person files too many meritless lawsuits or motions, a judge can label them a vexatious litigator, meaning they cannot file anything else without prior court approval. However, getting this label applied is incredibly difficult and requires a massive amount of evidence. Until that point, the victim is stuck in a cycle of responding to nonsense. In 2026, we are seeing the emergence of automated vexatious litigation, where bots are used to file pro se motions at a rate that a human lawyer cannot keep up with. The psychological toll of this lawfare is immense. Case studies in forensic psychology suggest that legal abuse can result in symptoms similar to post-traumatic stress disorder. The divorce lawyer in this context is often the only barrier between a client and total collapse. A good lawyer in 2026 has to be a hybrid of a legal strategist and a trauma-informed counselor. They must decide when to fight back and when to ignore the bait. If they respond to every jab, they drain the client's retainer. If they don't respond, they risk letting a false narrative take root in the court record. Another modern evolution is the weaponization of the Civil Protection Order. Historically designed to protect victims of domestic violence, these orders are sometimes used tactically to gain an immediate advantage in a divorce. A lawyer might advise a client that a temporary restraining order will give them exclusive use of the family home and temporary custody of the children before the other spouse even knows what is happening. While these orders are vital for true victims, the potential outcomes for someone falsely accused are devastating. They are removed from their home, cut off from their children, and forced to spend months proving their innocence while the other side solidifies their position. As we look at these dirty tactics, we see that the divorce lawyer has a dual nature. They can be the shield that protects a vulnerable spouse from financial ruin, or they can be the sword that cuts through a family's remaining stability for the sake of a client's revenge. This brings us to a critical question. As the legal system becomes more aware of these tactics, how is the profession of family law changing to stop them? Are we moving toward a system that prizes transparency and cooperation, or are we doubling down on the gladiator model? In the next part of this deep dive, we are going to look at the professionals who operate entirely in the background, the ones you never see in court. We will explore the role of the shadow consultants, the reputation managers, and the private security teams that high-profile divorce lawyers use to control the environment outside the courtroom. We are moving from the lawfare of the filing cabinet to the warfare of the public square. What happens when your divorce is not just a legal case but a PR campaign? The battle for the narrative is about to begin, and the stakes involve more than just money. They involve your very identity in the digital age. In the year 2026, the courtroom is no longer the only place where a divorce is won or lost. For the modern high-stakes divorce lawyer, the legal brief is merely one half of the strategy. The other half is a meticulously managed public relations campaign designed to win the heart of the digital public. This evolution from private family matters to public spectacles didn't happen overnight. Historically, in the 1950s and 60s, the goal of a prominent lawyer was to keep their client's name out of the newspapers entirely. A successful divorce was a silent one. But as the 24-hour news cycle evolved into the 24-second viral cycle, the strategy flipped. Today, silence is often interpreted as guilt, and the lawyer has had to become a master of spin. Imagine a high-profile case in 2026 involving a public figure named Chloe, a lifestyle influencer with 10 million followers, and her husband Zane, a tech entrepreneur. In this scenario, the primary asset is not just the house or the stocks. It is Chloe's brand reputation. If Zane's lawyer can successfully paint Chloe as an inauthentic or neglectful parent in the court of public opinion, her endorsement deals vanish before the first hearing. Chloe's lawyer, therefore, doesn't just hire a junior associate to research case law. They hire a crisis management firm. This is the birth of the narrative war. Step by step, the lawyer and the PR consultant coordinate a soft launch of the divorce narrative. Before the papers are even served, they might place a series of strategic leaks in high-tier digital outlets. These are not blatant attacks but subtle mentions of Chloe's commitment to her family during a difficult time. The goal is to establish a historical trend of Chloe as the primary caretaker. This creates a baseline of public sympathy that acts as a shield when the actual legal filings become public. If Zane's team attempts a bombshell filing, the public has already been primed to see him as the aggressor. Historical trends in the early 2000s saw the rise of the celebrity divorce as a tabloid staple, but those were mostly reactive. Lawyers like those who handled the high-profile splits of the 2010s began to realize that the press could be used to pressure the other side into a settlement. If one party is terrified of their private messages or business dealings being scrutinized by the public, they are far more likely to agree to a quiet, favorable deal for the other side. In 2026, this has evolved into the weaponization of social media algorithms. A lawyer might coordinate with digital strategists to ensure that certain hashtags or themes related to the case trend in specific geographic areas where the jury pool or the judge might reside. While it is technically illegal to influence a jury, influencing the general atmosphere of a city is a gray area that modern firms exploit with surgical precision. Consider the case study of the digital reputation scrub. In 2026, a divorce lawyer's checklist includes an immediate audit of the client's entire digital history. They use AI tools to find every controversial post, every questionable photo, and every angry comment made over the last decade. The lawyer then works with SEO experts to bury this content under a mountain of fresh, positive, and carefully curated new history. This is not just about vanity. It is about potential outcomes in a custody battle. If a judge or a court-appointed evaluator performs a search on Chloe, they need to see a dedicated professional and mother, not the partygoer she might have been in 2018. The lawyer acts as the editor-in-chief of the client's life. This creates a massive tension between the legal strategy and the PR strategy. A lawyer's instinct is to say nothing and save the best evidence for the trial. A PR consultant's instinct is to release everything immediately to win the news cycle. A 2026 divorce lawyer must balance these two competing forces. If they stay silent for too long, the other side's narrative becomes the truth in the eyes of the public. If they speak too much, they risk a gag order from a judge who is tired of seeing the case on the evening news. We have seen historical trends where judges, frustrated by the trial by media, have leveled massive sanctions against lawyers who use the courthouse steps as a press conference podium. Furthermore, we must look at the rise of the influencer divorce as a specific subgenre of law. In these cases, the lawyer has to value the social capital of a couple. If Chloe and Zayn shared a YouTube channel that generated $5 million a year in ad revenue, who owns the vibe of that channel? Who gets the followers? In 2026, lawyers are drafting digital partition agreements. This is a step-by-step legal process where the lawyer divides up digital assets like a digital real estate developer. They might negotiate who gets the primary Instagram handle, who gets the email list, and how the likeness of the children can be used in future content. This is a far cry from the 1980s when the biggest fight was over who got the family station wagon. Data from the last 5 years shows that cases involving a public narrative component take 30% longer to resolve and cost nearly double in legal and consulting fees. This is because every motion filed is drafted with two audiences in mind, the judge and the followers. The lawyer must ensure that every legal argument also functions as a soundbite. Case studies of high net worth individuals in 2026 show that many now include media neutrality clauses in their prenuptial agreements. These clauses stipulate that in the event of a divorce, neither party can post about the other on social media, speak to the press, or even allow their friends to leak stories. The lawyer's role has expanded to that of a digital enforcer, monitoring the web for any breach of these non-disparagement agreements and filing immediate cease and desist orders to keep the narrative contained. But what happens when the narrative can't be contained? What happens when a divorce becomes so big that it starts to affect the stock price of a major corporation or the stability of a political campaign? This is where the divorce lawyer enters the world of shadow consulting. These are the lawyers you never see in the news. They operate in the background, coordinating with private security teams to ensure the client isn't harassed by paparazzi, and working with reputation insurers to hedge against the financial fallout of a messy split. They are the invisible hands that guide the process, ensuring that while the public sees a drama, the business interests of the client remain protected in a cold, clinical vacuum. As we move toward the conclusion of this historical deep dive, we have to look at the final frontier. We have seen how the lawyer moved from the courtroom to the boardroom and then to the digital square. But there is one place left where the law is still struggling to catch up: the global stage. What happens when Chloe lives in New York, Zayn lives in London, and their assets are held in a decentralized autonomous organization that exists only on the blockchain? In the next part, we are going into the world of international jurisdictional warfare. We will explore how the world's wealthiest individuals play a global game of hide-and-seek with their fortunes, and how the divorce lawyer of 2026 has to be a master of international treaty law, just to figure out which country's flag should be in the courtroom. The map is the weapon, and the borders are about to move. The transition into international jurisdictional warfare is the ultimate high-stakes chess match for the 2026 divorce lawyer. In a world where capital and people move with the speed of a fiber-optic pulse, the traditional boundaries of the local county courthouse have become obsolete for the American elite. Historically, if a couple lived in Kansas, they divorced in Kansas. The laws were predictable, and the assets were physical. But as we look at the historical trends of the last few decades, we see the rise of jurisdictional arbitrage. a strategy where lawyers treat the globe as a menu of legal outcomes. This is the concept of forum shopping, and in 2026 it is the first and most critical move a lawyer makes. Imagine a character named Isabella and her husband Liam. Isabella is a high-profile executive for a multinational corporation based in New York, while Liam manages a private equity fund that operates primarily out of London and Singapore. They own a penthouse in Manhattan, a villa in the south of France, and significant interests in a decentralized autonomous organization, a DAO registered in the Marshall Islands. When the marriage begins to fail in 2026, the first lawyer to get to a courthouse doesn't just win the day. They potentially determine the entire financial future of their client. This is known as the race to court. In this international context, the lawyer's role is to perform a step-by-step audit of which jurisdiction offers the most favorable potential outcomes. Historically, London became known as the divorce capital of the world because English courts were perceived as far more generous to the non-earning spouse than many U.S. jurisdictions. Conversely, a lawyer representing a high earner like Liam might look to file in a jurisdiction that strictly adheres to prenuptial agreements or has a more rigid definition of marital property. The lawyer must analyze the lease alibi pendens rule, which essentially means that the first court to be properly seized of the case usually gets to keep it. If Liam's lawyer files in a favorable jurisdiction even 6 hours before Isabella's lawyer files in New York, Isabella could be forced to litigate her life on a different continent under laws that are hostile to her interests. The mechanics of this warfare involve the 1965 Hague Service Convention. A 2026 divorce lawyer cannot simply hand a petition to a spouse at an airport and call it a day. To establish jurisdiction over an international party, the lawyer must follow a rigorous, step-by-step process of serving papers through a central authority in the foreign country. This process can take months and involves translated documents, diplomatic channels, and high-level coordination with local counsel in the target country. If the lawyer misses one procedural step in the service of process, the entire case can be dismissed for lack of jurisdiction, allowing the other spouse to race to a different court and file their own petition. This brings us to the most emotionally charged aspect of the international divorce: the 1980 Hague Convention on the Civil Aspects of International Child Abduction. In 2026, this treaty is the primary weapon used by lawyers when one parent takes the children to a foreign country to seek a tactical advantage. Imagine Liam takes the children to visit family in a non-signatory country and then refuses to return them, claiming the children are now residents there. Isabella's lawyer must immediately initiate a Hague petition. This is a specialized legal proceeding where the goal is not to decide custody, but to decide the children's habitual residence. The lawyer must present a historical timeline of the children's lives, where they went to school, where their doctors were, and where their center of gravity existed before the move. Historical trends show that these cases are a sprint. If a lawyer waits too long, the child might settle into the new country, making a return order nearly impossible to obtain. The financial side of this global hide-and-seek involves the Offshore Asset Protection Trust. In the late 20th century, lawyers used the Cook Islands or Nevis as black holes for marital wealth. These jurisdictions have laws specifically designed to make it nearly impossible for a U.S. court order to be enforced. If Liam has moved marital funds into a Cook Islands trust, Isabella's lawyer in 2026 faces a massive wall. To even bring a claim against that trust, the lawyer might have to travel to the islands, hire local counsel, and prove fraudulent transfer under a standard of beyond a reasonable doubt, a much higher bar than the preponderance of the evidence used in U.S. civil courts. Furthermore, the statute of limitations in these jurisdictions is often as short as 1 or 2 years. The lawyer's role has evolved into a forensic hunt across multiple time zones, trying to find the point of entry, where the money left the U.S. jurisdiction. In 2026, the digital frontier has made this even more complex. We are now seeing the emergence of jurisdictional disputes over virtual property. If Liam and Isabella's primary wealth is held in a DAO that has no physical headquarters, where is the property located? A lawyer might argue that the property is located where the private keys are held, while the other side argues it is located where the smart contract was deployed. This is the new frontier of international law. The divorce lawyer must work with international tax counsel to understand the potential outcomes of moving these assets across borders. A mistake here doesn't just lead to a bad settlement. It can lead to massive tax penalties and even criminal investigations for money laundering or tax evasion. Case studies from the early 2020s, such as the high-profile divorces of tech billionaires, show that these international battles often end in a global settlement. Because neither side wants to spend 10 years litigating in 5 different countries, the lawyers eventually sit down in a neutral territory, often a private office in a city like Zurich or Dubai, and negotiate a private contract that resolves all claims worldwide. The divorce lawyer here acts as a treaty negotiator. They are drafting a document that must be enforceable in multiple jurisdictions, which means it must comply with the public policy of every country involved. Data indicates that international divorces now represent nearly 15% of all high net worth cases in the United States, a 300% increase from the 1990s. This has created a specialized breed of global divorce counsel, who do nothing but manage these multi-jurisdictional headaches. They are the architects of the legal map, choosing which hills to die on and which borders to cross. They understand that a win in a U.S. court is meaningless if you can't seize the assets in a Swiss bank or a Singaporean brokerage. As we reach the peak of this masterclass, we have traveled from the staged adultery of the 1940s to the algorithmic trials and international lawfare of 2026. We have seen the lawyer transform from a moral arbiter to a financial strategist, a digital detective, and finally a global negotiator. But there is one final question that remains. After all the technology, all the offshore trusts, and all the media spin, where is the human element? In our final part, we are going to look at the legacy of the law. We will explore how the historical role of the divorce lawyer has fundamentally reshaped the American family. We will look at the final verdict on the profession. Has the lawyer become a necessary evil in a complex world? Or are we moving toward a future where the lawyer is finally obsolete? The final part of the deep dive is about to reveal the ultimate outcome of 2 centuries of legal evolution. As we approach the final verdict on this 2-century evolution, we must confront the central paradox of the modern legal landscape. In the year 2026, the divorce lawyer exists in a state of hyper-specialization, yet the very technology that made them more efficient is now threatening to make the traditional litigation model obsolete. To understand the potential outcomes for the future of the American family, we have to look at the final pivot of the profession, the move from the courtroom gladiator to the social architect. Imagine a couple in 2026 named Marcus and Elena. After traversing the digital discovery process and the algorithmic alimony assessments we discussed earlier, they find themselves at a crossroads. They could continue down the path of high-conflict litigation, paying their respective attorneys $500 an hour to argue over the fine print of a digital asset split, or they could engage in what is now the fastest-growing sector of family law, collaborative practice. Historically, the trend toward collaborative law began in the 1990s as a reaction to the trauma caused by the adversarial system. In 2026, this has evolved into a step-by-step multidisciplinary process that bypasses the judge entirely. In a collaborative 2026 divorce, Marcus and Elena each hire a lawyer, but they all sign a contract that forbids them from going to court. If the process breaks down and they decide to litigate, both lawyers are disqualified and must withdraw from the case. This creates a powerful financial and professional incentive for the lawyers to find a middle ground. The role of the lawyer here is not to win, but to facilitate. Step by step, they sit in a room with a neutral financial professional and a child specialist. They don't look at what the law mandates, they look at what the family needs. Historical trends show that families who use this model report significantly higher satisfaction levels and lower rates of post-divorce litigation. The lawyer becomes a peacemaker, using their deep knowledge of the law to craft creative solutions that a computer algorithm could never imagine. However, as Isabella and Liam's case from the previous part showed us, not everyone is willing to collaborate. For those stuck in high-conflict cycles, the role of the lawyer is shifting toward that of a reputation and digital legacy guardian. Case studies from 2025 and 2026 reveal a disturbing rise in deepfake litigation. Imagine if Liam, in an attempt to gain the upper hand in a custody battle, uses generative AI to create a convincing video of Isabella appearing to neglect their children. In the past, a lawyer would just cross-examine a witness. In 2026, Isabella's lawyer must be a digital detective. They hire forensic video analysts to examine the metadata and the lighting consistency of the file to prove it is a forgery. This is the new front line of the profession, protecting the very truth of a person's identity in a world where data can be easily manipulated. We must also consider the historical trend of the gray divorce. Data from the U.S. Census and the American Bar Association shows that while divorce rates for younger generations are stabilizing, divorce rates for those over the age of 50 have tripled since the 1990s. This has created a specialized role for the elder law divorce attorney. For these clients, the lawyer isn't arguing over child support, They are arguing over the division of complex pension plans, long-term care insurance policies, and the potential outcomes of a Social Security split. The lawyer must understand the intricate intersection of family law and estate planning. If Marcus and Elena were 70 instead of 40, their lawyer would be focused on how to ensure both parties can afford a dignified retirement in a high-inflation 2026 economy without liquidating the family's legacy assets. Step by step, the lawyer in an elder divorce must coordinate with tax professionals to avoid massive capital gains, hits on homes that have been owned for 40 years. They must navigate the complexities of Medicare and Medicaid eligibility, ensuring that a divorce settlement doesn't accidentally disqualify a spouse from vital health benefits. This is where the lawyer acts as a life-stage consultant, managing the sunset of a marriage with the same technical precision that a venture capital lawyer manages the exit of a startup. But is the lawyer truly becoming obsolete? We are seeing the rise of the DIY divorce platform, the Uberization of the legal system. In 2026, a couple with no children and few assets can download an app, sync their bank accounts, and have a divorce decree generated by an AI for a flat fee of $99. For the bottom 40% of the economic ladder, the lawyer has already been replaced by the interface. Historical trends suggest that as basic legal services become commoditized, the only lawyers who will survive are those who handle the extremes: the extremely wealthy, the extremely complicated, and the extremely contentious. This leads to the ultimate outcome of our historical deep dive. The divorce lawyer of the future is no longer a generalist. They are a highly specialized consultant who manages the shadow of the law. They are there for when the algorithm fails, when the international treaty is ambiguous, or when the digital evidence is forged. They have evolved from the 19th century lobbyists who petitioned legislatures to the 21st century social architects who designed the new structures of American life. They have shaped how we view property, how we define parenthood, and how we value the individual's right to pursue a different life. The legacy of the American divorce lawyer is written in the statutes of every state and the bank accounts of every family. They are the ones who turned the end of a marriage from a religious sin into a civil transaction. They are the janitors of the American dream, cleaning up the mess when the pursuit of happiness leads two people in opposite directions. As we look ahead, the profession will continue to mirror our society. As we become more digital, the lawyer becomes more forensic. As we become more global, the lawyer becomes more diplomatic. And as we become more automated, the human element of the lawyer, the ability to provide empathy, strategy, and creative compromise, becomes the most valuable asset of all. We have traveled from the hotel room setups of 1948 to the blockchain audits of 2026. We have seen the rise of the super lawyer, the weaponization of the motion, and the emergence of the AI judge. But the story of the divorce lawyer doesn't end with a final decree. It continues in the next chapter of human relationships. What happens when we stop talking about how marriages end and start talking about how they are engineered from the very beginning? If you think the battle for the divorce settlement was intense, wait until you see the rise of the pre-marriage industrial complex. In our next series, we are going into the world of the smart marriage contract, where your future alimony, your custody schedule, and even your fidelity are pre-programmed into a digital agreement before you ever say I do. Are we moving toward a world where the divorce lawyer is replaced by a software engineer? And what happens when a computer code decides the fate of your family before the first argument even happens? The era of the pre-programmed marriage is arriving, and the legal implications are more shocking than anything we've seen in the last 100 years. Stay tuned for the next deep dive into the future of human contracts.